Mr. Neumeister will have a seat. We'll get the committee started. Today is February 12th, 2025. Call the Senate Judiciary and Public Safety Committee to order. We do have a quorum present. We're going to start out with a presentation by the Uniform Law Commissioner. So we'll welcome the testifiers to come to the table and tell us all about the Uniform Law Commission. Not sure who wants to start, but if you go ahead and identify yourself and your position and go ahead with your testimony.
Thank you, Chair Latz. My name is Kim Lowe. I am one of your Minnesota Uniform Law Commissioners. I'm also a legal practitioner here in the Twin Cities. Many of you have heard me speak before on various topics, but here I'm in my capacity as a commissioner for Minnesota. So we thought today we would just give this committee has heard us before. You know what we do. We'll give you a brief overview of the Uniform Law Commission, and then we'll tell you kind of what we've been working on, and then Commissioner Timmons will talk to you about our budget and what we're asking for, but we'll be very quick because we know you have a very full agenda today. For those of you who don't know, and many of you do already, the Uniform Law Commission is an over 125-year-old nonprofit organization. It is an organization that's been in existence for a very long time. It is made up of commissioners who are appointed by the various states. Every state has and territories have the ability to appoint commissioners to the commission. All the various commissioners come together and we work on drafting projects that are meant to be uniform and promulgated back to the various states. One of the ones most people hear me talk about, and we passed amendments to it last year, is the Uniform Commercial Code. That is the preeminent product that comes out of the ULC. And so typically what happens with the ULC drafting projects is someone will suggest some sort of uniform law that they think might be worthwhile. We'll study it. The commission will study it for at least 2 years. And then if somebody thinks we should go to drafting, then we'll spend at least 2 years in drafting committees, drafting a product, what we call a product, a uniform act. And at our annual meetings, the Uniform Law Commission, all commissioners get together. It's much like a legislative process that you all go through. We'll look at every act, we'll read it line by line, it's repeated, it's parsed through, and then we come up with a final product that we hope will be brought back to the states and enacted at the various state level. We have enacted in Minnesota several uniform acts. Many of you have heard us talk about them over the years. Recently, we enacted the Uniform Commercial Code, whose amendments came through in 2022. We also enacted the Uniform Protection of Public Expression Act and the Uniform Electronic Wills Act in the last session. One thing that's important for everyone to remember, and it's sometimes forgotten, that all of our commissioners serve as volunteers. We are not paid for the work that we do. We do, however, have a budget line in the state budget, and I want Commissioner Timmons to talk about that, so that's what we're here for today.
Ms. Lowe, can you just, before we go on, could you tell us what is the value of uniformity among the states on some of these bills or laws?
Chair Latz, that's a great question. People ask me, I'm going to speak as a legal practitioner and a business law practitioner first and foremost. The benefit of uniformity, especially in the world we live in today, and especially for purposes of business and people that transact business, is of certainty that when activities cross state lines, that the rules are similar or the same. I brought up the Uniform Commercial Code. That is the preeminent example of why uniformity matters. That code allows businesses to interact state by state, across state lines, and internationally. It is in many ways lauded as the most beneficial concept of the U.S. economy because it allows all of this interaction with certainty across state lines. That code, the Uniform Commercial Code, implicates banking. It implicates things like securities laws. It implicates what we used to write called checks. Last year I talked to you about technology and how the money processing system works. All of that, whether we like it or not, crosses state lines. And the benefit of uniformity is that when things cross state lines, if they're uniform, we all do better. Then we also work on many acts that we also would like to be uniform, such as how we access technology. A lot of trust and estate vehicles that people have, people cross state lines, they have family members that are in different states. If the uniformity exists in those sorts of products and laws, it's easier for individuals and families to negotiate the legal system if there's some certainty that there's similarity or uniformity across state lines.
So one of the values that I see also is just that the minds, the experience of the lawyers across the country that work in these particular fields have had a chance to survey, in essence, and determine the best practices from the different states. And so it becomes a good recommendation of what they think that the highest, the best level of the law ought to be in a particular field. So for me, it comes as sort of a recommendation, not only the value of state to state having some consistency, but a recommendation from national practitioners who have had the benefit of seeing how other states handle it, what the best practices would be here in Minnesota as well. So that's how I take it when there's a proposal. Is that a fair characterization,
Sure,
Ms. Lowe?
Kimmel, that is a very fair assessment. Many of you know that I work on model acts and uniform acts around the country. I sit at tables with practitioners from every state, other countries, working on these issues. And it's very informative to have multiple minds thinking about the same question and getting different perspectives and coming to a policy decision that hopefully is the best policy decision for most of the actors. And that's really only possible when we all collectively come together and work together. One thing that I forgot to mention is that all uniform law commissioners at the time of their appointment do need to be licensed lawyers. Not saying that we're better or worse, but there is a requirement for licensure. But all of the uniform law commissioners come from either academia, practitioners like me. I am not one of the most, there's not that many practitioners, lawmakers like yourself, or judges is where most of the uniform law commissioners come from. So they come from a universe of experience in the law in their own states, and they bring that together to work on products that we then bring forth back to the states that we hope will be enacted.
So just like we give a great deal of respect to most of us anyway, I would assume to the State Bar Association recommendations, we're going to hear one. We've already had a couple of them in committee. We got more coming. Because of the process they go through, the consensus that they develop among the practitioners on all the different perspectives of a particular field. The Uniform Law Commission products and recommendations go through a similarly rigorous vetting process, but from a national perspective. So I personally, that's one reason I find it so helpful. Ms. Lowe?
And we also work directly with the Bar Association on some of those products. Through what you've heard already this year are products that we worked with them on. They're not uniform, but we brought uniform parts to a lot of what they do. So a lot of our work as commissioners is to actually work with the bar and other organizations and stakeholders to get the very best laws that we can in Minnesota. They might not be uniform from our perspective, but we still bring that to the table, and we want to be resources for all Minnesotans when it comes to lawmaking.
Thank you. Ms. Timmons?
Yes, for the record, I'm Michelle Timmons, former reviser, and now I've been a uniform law commissioner for going on 27 years, I think. And today I just wanted to talk a little bit about what is probably the smallest and least complicated budget this group will look at. Our request is actually for a same level budget, which is $115,000 each year or $230,000 per biennium, which is the same as it was the last 2 years. And that's at the governor's recommendation, and it's at a level that allows us to continue the same level of volunteer service that you've heard discussed by Commissioner Lowe. There are really only 2 cost centers in the Uniform Law Commission budget. One is the annual dues that are paid to the Uniform Law Commission by the state, which is going to be $73,620 in the first year and $77,300 in the second year. So those are going up. Those are based on the population in the state. So, for example, the states of New York and California pay much bigger dues than does Minnesota, and then states like North and South Dakota, our neighbors, will pay less because of lower population. The second cost center is the travel costs, travel reimbursement for the Uniform Law Commissioners to go to the annual meeting. The annual meeting is required for all commissioners to go unless they have a good reason not to, usually a health reason. Otherwise, because it's like a legislative session, it is something that commissioners need to attend to be able to participate in drafting the acts, as we've already discussed. So what has happened, though, is, for example, at the time that the governor's budget narrative was drafted, we had 12 Minnesota Uniform Law Commissioners. But at that time, Commissioner Michael Sullivan let Commissioner Bob Tennyson, who was putting the budget together, Mike let Bob know that he anticipated he would not be able to travel in the upcoming biennium. So Bob budgeted for 11 Uniform Law Commissioners rather than the 12. And that decrease in the travel costs was able to allow us to absorb the increases in the dues. Mike Sullivan was a gem of a guy, and he did pass away late in 2024. So we are, in fact, down to 11 commissioners at this time, and Mike will be a tremendous loss for Minnesota and the Uniform Law Commission. But the net result is that we are able to manage with a same level budget request, and that is what we are asking for. I guess with that, if you have any additional questions.
Ms. Timmons, is there any anticipation of an appointment to replace Mike Sullivan?
I can take it.
Any expecting a replacement for Mr. Sullivan to be appointed?
I'm sorry, Senator Latz, I didn't quite hear the end of the question. No, because of the fact that Commissioner Sullivan was a life member. The way you become a life member is to have been appointed through the core appointment process by the governor, the Chief Justice of the Supreme Court, and the Attorney General, or have been the reviser of statutes and been there for 20 years. And then if you pass that time mark as a Uniform Law Commissioner, by virtue of the documents of the Uniform Law Commission itself, you become a life member. And then under state law, you are considered a Uniform Law Commissioner of the state of Minnesota and eligible to go to the annual meetings and receive the reimbursement.
When a person transitions from appointed position to a life member, does that then open up the position that they held from an appointed standpoint for a new appointment?
Yes, Senator Latz and members, that is correct.
Okay. Ms. Law.
Senator Latz, thank you. I just think we do want to recognize we do have an opening in the commission right now. There are 4 appointed seats. One is the reviser, and then there are 3 open seats. I hold one of them. If you want to unappoint me, you can. I hold one of them. Melissa Hortman holds the other, and there is an opening. It was held by Gary Jenkins, who was the University of Minnesota Law School dean, who has transitioned away. That appointment is open. We are in the process of, we have somebody in mind to be appointed, but that is open right now. So we do have 1 seat that's open. But we budgeted for that seat to be filled.
Oh, you did already. That's included
We
in the budget
assumed it would
proposal
be
here.
filled, yeah.
Correct.
Okay.
We're just waiting for things to settle down.
Aren't we all? All right. Thank you for that. Any questions from members of the committee or comments? Senator Cruin.
Thank you, Mr. Chair, and I think you were looking at me too much when you were talking about that opening on the commission. No, thanks. No, I appreciate the work that you're doing. I know that the the changes to the Uniform Commercial Code we did last year was probably the most exciting thing to hit the Senate floor. So you do good work. I think that, you know, $115,000 a year will pay for itself exponentially in commerce and smooth commerce, so it's worthwhile. That's all I had to say. Thanks.
Nice to have bipartisan support for a budget item.
All right.
Any other questions or comments from members of the committee? Not seeing any. Thank you both for your service and for your testimony here today.
Thank you.
Thank you.
Now we're going to hear a presentation by the Minnesota Competency Attainment Board, and we'll invite Kim Larson, the program administrator, to come forward. Ms. Larson, whenever you're ready, identify yourself and your position, and then as others are testifying, they can do the same. Thank you.
Thank you, Senator Latz and members. It's nice to be here this afternoon. I was told to bring a laptop so that something could be displayed for all of you, but I also am fine working from paper if that's what's needed. I'm Kim Larson. I'm the program administrator for the Minnesota Competency Attainment Board. Thank you. And maybe while I get connected here, I'll ask the two on either side of me to introduce themselves.
Sure, go ahead, sir.
Good afternoon. My name is Ryan Flynn. I'm the chair of the Minnesota Competency Attainment Board.
Mr. Chair, thank you. I'm Elliot Boutai. I'm the vice chair of the Competency Attainment Board.
Okay,
You can go ahead with your presentation. We see the presentation on the screen in front of us.
great. Thank you. So just a quick overview of what we're going to talk about today. We're going to do a quick reminder of how the Minnesota Competency Attainment Board came about. We'll talk a little bit about what we call the soft launch portion of our work. I'll cover some of our growth plan for the coming couple of years, and then we have some time to run through our budget request. I won't go through during this presentation the defendant stories that are in the appendix. I share those for your own review at a later time, but if there's questions, I'm happy to field those today as well. So the Minnesota Competency Attainment Board came about through legislation in the 2022 legislative session. The general purpose of it was to fill the gap, so to speak, of folks who are in the criminal justice system who have been found incompetent to proceed with their case but are not civilly committable. And in Minnesota, that is the majority of criminal defendants where this question is raised. So during the 2022 session, it was a bipartisan bill that created or was added to Chapter 611 of Minnesota statutes creating competency proceedings. Within those competency proceedings, it created the Minnesota Competency Attainment Board, the Forensic Navigator Program, and duties and responsibilities related to both of those new programs. 2023, there was some language clarification that occurred during that legislative session, and that shifted our implementation or effective date to April 1st of 2024. And then you may or may not be aware, the Rules of Criminal Procedure, Rule 20, which largely governed competency proceedings prior to the new legislation, were amended effective November 1st of 2024 to be more closely in alignment with the new statute rather than at odds with each other. So the legislation created the Minnesota Competency Attainment Board as an independent board within the judicial branch. And then you can see on the slide, there are other independent boards within the judicial branch that I've listed. And then we also have the mission and vision that was established by the board in their first few months of operation. So the board is outlined and duties and responsibilities for it are provided in section 611.56 of the statute. There are 7 members from a variety of backgrounds. 4 are appointed by the governor, and 3 are appointed by the Minnesota Supreme Court. Based on this statute, the board is charged with creating and administering a statewide independent competency attainment system. They are responsible for certifying competency attainment programs, and then they're also responsible for establishing a forensic navigator program that's aimed at promoting prevention and diversion, supporting defendants through the process, and assisting courts in coordinating those services. So forensic navigator services are also outlined within the statute duties and responsibilities. What I have here on this slide for you are some examples of the things that our forensic navigators do, and then also some of the services that are not included in their roles and responsibilities. So the board was first appointed and started meeting in July of 2024. In their first few months of meeting, they realized the enormous task of establishing a brand-new state agency without any structural supports or infrastructure in place. And so one of the first things they started talking about was the disconnect between being able to be fully staffed and meet the needs statewide by the time April 1st, 2024 came along. And so they started talking about the work as a soft launch. There were 3 goals that they established for this soft launch phase. The first one was, of course, to start building the program. The second one was to hire approximately 10 forensic navigators, 1 in each judicial district, and then to start providing services in both Metro and Greater Minnesota. So to the first goal, where we are today, this is just an example, creating the agency structure. We had to establish just the basic supports for employees, and so that included everything from getting access, secure access to the internet, establishing security controls, getting an email domain, Microsoft licenses, and establishing some of our baseline policies that guided our work. The other part of building the program was the hiring. So here on this slide, you see the current complement of employees at the Competency Attainment Board and a picture of when each of those employees was brought on board. The second goal was to hire approximately 10 forensic navigators, 1 per judicial district. This slide shows that we have exceeded that goal and have hired 20 forensic navigators as of today. The stars on the map give you a visual of where they reside around the state of Minnesota. And then to the goal of providing services in both Metro and Greater Minnesota, this slide gives you just a quick snapshot of the some data related to the cases. So orders that we've received from courts include reference to 1,599 defendants. This data is as of the end of December, so the numbers are actually higher today. That represents just under 3,000 cases, and 68 of 87 Minnesota counties have sent orders to our program. On the assignment side, this is the coverage that we have with our current forensic navigators. So our current navigators are working in 637 cases with 355 defendants and covering 57 of those 68 counties. And just a little more data here on this slide. So this is organized by judicial district. The data in column 2, orders by the court, is data that we received from the judicial branch court system, and it reflects all of the orders for a competency examination that have been documented in their case management system. And this is just for calendar year 2024. The note that I want to make about that data is that there are often multiple orders in a single case. So the numbers of orders are not one-to-one with cases in the state of Minnesota.
So Ms. Larson, if I may
Yes.
just clarify, the orders that you're referring to, are those Rule 2001 orders? Or is there
Yes.
something more than that involved?
They are, correct, that's
Okay.
correct.
All right, thank you.
You're welcome. And so then the orders received by us in column 3 shows how many of those Rule 2001 orders that we've received from the courts. And the qualifier here is that we just started receiving orders in April of 2024. So the data that we've received is only reflective of 9 months of 2024. So we still don't quite have a one-for-one comparison match with court data. And then the second component of this information is just to show you the coverage that we've attained in the different judicial districts. So the percentages that you see here are the percentages of cases in which a forensic navigator was or is currently assigned to work with a defendant in that district. All right, so the other component of the board's responsibilities is to certify competency attainment programs. Currently, we have 9 certified programs, and you can see the list there. They are scattered a little bit around the state of Minnesota, but most of them are centered in the metro area. And we did start receiving applications or accepting applications in April of 2024. So our growth plan, there's a lot more that we have to do, but just to kind of sum it up in 3 goals, we are looking at hiring approximately 50 additional forensic navigators by the end of this fiscal year. We are also looking at being able to stabilize our timelines and responsiveness as we staff up and have more resources available to do the work. And then there's also just some ongoing clarification of duties and responsibilities that we'll be working on in collaboration with our justice partners. And so to our budget request, as you've heard me mention, we are not fully staffed yet. Our budget request is based on the numbers and employee numbers that were included in the original underlying fiscal note for the creation of the Competency Attainment Board. And so what we're looking at really is just the opportunity to get fully staffed and then maintain those core operations. So the breakdown on the slide, I've just given you the total number request, but encompassed in there is a request for 6% wage increases for our employees, the amounts that we believe we'll need to support the health insurance premium increases for employees. And then that original fiscal note did not include consideration of an operating budget for the board. And so we've added on a 10% request for operating budget. We went with 10% because I understand that's generally about the amount that most state agencies spend on operating costs versus personnel costs. And that is the end of our formal presentation.
Thank you, Ms. Larson. Can you answer one question for me? What exactly do the competency attainment programs do?
That's a great question, and it's a little different for each program. So the certification component comes about via the statute, where there's this new added consideration of providing competency attainment education to individuals in conjunction with their any therapeutic treatment that might be necessary for them. So really what we're looking for in those certified competency attainment programs is their ability to provide the combination of therapeutic services along with the competency attainment educational components. And those are really aimed at helping and making sure that defendants understand the court process, understanding what their charges are, what the potential outcomes of their charges are, who the different players are in the courtroom, and then also being able to participate in their case and rationally consult with their attorney.
In other words, all of the criteria that a judge will use to determine whether someone is competent to participate in their own defense.
Correct.
All right. The goal then being to raise them to the level of competency, but not necessarily, probably impossibly so, to cure the underlying mental health issues, which would require long-term, often lifelong services, right?
That's correct, Chair Latz, and also to bring them to the point where they can resolve their case in the court system.
I see. Okay. Thank you. Did either of your testifiers wish to add anything to the testimony, or available to answer questions? If you want to wade in, we'd welcome your input. Maybe you can tell us a little bit, just a brief sketch of who you are and how you came to be involved in this, what your background is.
And in the interest of your time,
Mr. Flynn.
I'll give a still a long but abbreviated explanation about how I fell into this. So I'm a prosecutor. I'm currently a prosecutor in Ramsey County. Prior to that, I was a prosecutor in Chisago County, been prosecutor for just under 15 years. I fell into this when I discovered the gap which prevented us from being able to find either a just solution for either the victims in a case or the criminal defendant in a case. As you all, many of you know, the gap received a lot of attention when it became so bad. Everyone started talking about it a few years ago, and we had been working on it for years to try to find a solution. First off, thanks to the members who were here, part of that last-minute bipartisan solution that was passed years ago. When the MCAA got a membership on that board, they asked me to jump in. There was not a long list of people who are trying to become chair of that board, but so I volunteered. We then immediately started working on trying to figure out how we get established a new state agency and to meet the significant demand. So we have been pulling in input from judges, NAMI, public defenders, caseworkers from across the state, and really been working to try and get this program up and running. And we're pretty thrilled with where it is, given sort of the situation we had. And now what we are asking for simply is the ability to meet the demand that was asked of us originally. Some of you remember that originally we wanted to be able to borrow the services and the administrative abilities of other agencies, and that just for a multitude of reasons didn't come to fruition. So we're met with the sort of unanticipated problem of we didn't have an operating budget, but we had a significant demand for operations, the HR, budgeting. Turns out when you start a state agency, it doesn't come with a checkbook and a brochure. So we had to figure that all out on our own. So now that we have that, we're really just hoping for that additional funds so that we can meet the original anticipated number of forensic navigators across the state.
Thank you. Mr. Boutai?
Thank you, Mr. Chair. I'm the Senior Policy Coordinator at NAMI, Minnesota, the National Alliance on Mental Illness. We've really been watching this issue for many years, and a lot of it came to a head when DHS changed their policy to stop waiting until a person was competent to discharge them from the state hospital. And what that allowed them to do was to take a lot more people in the state hospital from the community, which was really important. But it also left people leaving the state hospital, again, without being found competent. And so, we represent people with mental illnesses. Those are our people that are in the state hospital. And I think the last thing I would mention is that there's also thousands of defendants who are charged with misdemeanors, and those are automatically dismissed when the defendant is found incompetent. And what we found is that creates a revolving door. They commit a crime, a misdemeanor, they are found incompetent, and they're put right back out on the street with no other resources. So a lot of the work that we put into the legislation and now also being a part of the board is trying to close those gaps for people at all levels, whether that's civil commitment and needing to become competent, or small misdemeanors, so that we stop people from recycling in and out of our jails and our hospitals and this system. So really a benefit to people with mental illnesses and their families.
So thank you for that, and thank you for your service. I know in my own practice, I've seen more Rule 20 cases in the last several years than I did in the 20 years before that. So it's coming along, and sometimes people are held in custody because they won't show up for the competency exam with the forensic psychiatrist. The only way to make that connection is to hold them until the psychiatrist can get to them, either in person or with a remote or virtual interview process. So it's not easy, and we got a bunch of sheriffs coming in who can attest personally to to those who are facing mental health crises, competency issues that are being held in their jails, pretrial detention, or waiting for other placements in the community. So it's a much bigger picture than just this. Obviously, if they are found to be competent, then the question may often turn to what was their mental health status at the time of the incident that led to them being charged with a crime, and can they be held guilty, culpably guilty of the crime if they were in fact undergoing a mental illness episode at the time. That's a whole nother process that uses many of the same judicial and scientific resources. But I just want to give a shout out, appreciation. Senator Draheim carried the bill in 2022 that established this board in process, and Representative Edelson did in the House as well. So it was a very heavy lift at the time. We appreciate all of their work in doing that as well. Any questions or comments from members of the committee? I'm not seeing any, so thank you so much for your work and for being here today.
Thank you, Mr. Chair.
Thank you.
So the next item on our agenda is Senate File 59. We're going to look for Senator Green, who we think may have stepped out into the hallway, and we'll let him know that it's his turn. Senator Green, come on forward. Senate File 59. Senator, why don't we have you, well, I'll just note that there's some letters in the file, members, along with, of course, a copy of the bill. We are anticipating some remote testimony. And we have, this comes to us from State and Local Government Committee. We have some jurisdiction over portions of the bill. So what we'd like to do is have an overview briefly of the bill itself, and then we're going to focus our attention on the provisions that are within this committee's jurisdiction. And we'll see where it goes from there, what issues come up, and whether we're able to address those today. My understanding is if we are able to resolve those today, then the plan would be to return it to State and Local Government Committee, is what I understand, because I think there are still some matters to be worked out there. Is that correct, Senator Green?
That is my understanding. There's some issues with the legal portions of the bill that I'm learning more than I ever thought I would know when this stuff comes about. But yeah, I think that's what the path would be.
Okay, so that's sort of our course today then. Senator Green, if you go ahead and give us a summary of what your bill does, and then we'll tackle it from there.
Okay, a little bit of background is that I was getting contacted by, it's not an exaggeration to say, numerous people on some boundary issues they're having on their land, where the surveys were being done for various reasons, and they were coming in with new GIS equipment and actually moving boundary lines that have been in place and established for many years. And there was some confusion over where the old monuments were. And so as I was reading, it appeared to me that the monuments that were set in place back in the 1800s are the true boundaries of those lands. And over the years, they've been allowed to deteriorate. And it is the county's responsibility to keep those monuments up. And so what this bill is doing, and the intent of this bill, is to have those monuments reestablished and avoid what I think people have been bringing to me, which is to say it's going to cause a lot of litigation. I think we have litigation coming. And what this is trying to do is avoid that by saying we're going to reestablish the monuments, put them in place, and then that will be the same, hopefully the same boundary lines that were set 100 years ago.
All right, now we're going to ask, maybe council can identify for us what provisions of the bill are within our jurisdiction for focus, and then we'll take testimony. Ms. Primo.
Mr. Chair and members, that would be sections 2 and 3 of the bill.
Senator Green, do you want to tell us what those sections intend to accomplish?
Yes, Mr. Chair, thank you. The first portion of that, subdivision 4, it just tries to establish that, in fact, I'll talk about some of the confusion that this has caused. Apparently, people are reading this, and maybe this is the way it reads, that every monument that's set and every line that has to be drawn is going to end up in litigation. And the intent of this is not that. The intent of this is that if you have a boundary line that with the new equipment has come in and been moved from its former position, that there has to be a process now, because it's been reestablished falsely, in my opinion. It has to be reestablished back where it was. So for the existing monuments that are there that you would have to, that hopefully this bill will help us find, this would not apply. It would only apply to anything that's been moved within the recent years. The second part of the bill I think that you're talking about is pursuant to section 508.671, and that's also at the top of the other one. I did not realize that there were two different laws that dealt with the boundary lines, and one was abstract and one was maybe, I think, torrent, yeah. And so what we need is abstract.
For the record, that was Senator Cruin.
Okay, and so I guess what we need is abstract, and I have talked to attorneys, and they're willing and able to help me through those changes that we need.
All right, well, why don't we hear our testimony? While we're getting, we have an online testifier, while we're getting that set up, someone can correct me if I'm wrong, but I seem to be drawing back now to high school literature. Wasn't there a story of Giants in the Earth in which one of the stories in the history of Minnesota, or in that story about exactly this kind of a conflict over the movement of boundary lines, and there was some big battle between neighbors over that? Anyone? Senator Limmer, you were probably around during those days. Do you remember? Someone's going to correct me and say I'm completely off base here. But I can only imagine that the conflicts, I think there were some settlers that had put their boundary posts down and then left and then came for the winter and came back the following spring, and they weren't where they thought they were supposed to be, and then there was a big dispute, pretty violent dispute between neighbors over whether someone had moved boundary markers. So I can understand property lines and their importance. So I'm glad that we have this before us today. All right, we have testifying, I believe Alan Olson is joining us. Mr. Olson, if you would go ahead and identify yourself for our public record here and your affiliation, and tell us what you'd like to say.
Good afternoon. My name is Alan R. Olson. I live at 44389 393rd Avenue Southeast, just north of Langby, Minnesota, in Polk County, Columbia Township, which is just along US Highway 2. I was asked to testify by Mr. Steve Green about some property line discrepancies and survey issues we have experienced in our county. My neighbor Daryl Donnell and I had contacted Senator Green. My parents purchased the property I live on in 1959. It was 60 acres originally. It was homesteaded in 1894. Only 3 families have owned this property. My parents sold 10 acres to a couple in the middle 1960s, and that is the property my neighbor Daryl Donnell currently owns. Around 2010, Daryl applied and received a permit to build a storage building. The county sent him a map of his boundary lines and the setback, and he built the building. About 4 or 5 years ago, Daryl applied for another building permit to build a garage closer to his house move his old garage and attach the new garage to his house. It was denied. The county said he didn't own his well and septic because the new survey showed it to be on my property. The well and septic are legally spaced about 50 feet west of his house. The well and septic were updated in the late 1980s and early 90s, and I know this because my brother-in-law owned the property at that time. What changed from 2010, when everything was fine, according to the county, until now? The only thing we know of is the new survey. Daryl's bank will not give him a loan because of this error. Daryl has spent thousands of dollars in legal fees trying to rectify this. Daryl even purchased some property that came up for sale next to my property with the intent we would just trade some land to solve this. Daryl has contacted a couple different surveyor firms to survey this, but none of them will touch this because they say they won't be able to get it certified because of the messed up property lines. The Polk County engineer sent Daryl and I a letter stating we needed to settle this matter civilly in court. Daryl and I are not disagreeing, disputing, or feuding over this matter. I know where the lines are. The buildings and the land haven't moved. Why should we have to pay an attorney to straighten this out? The engineer also told Daryl and I to just go out and drive a stake where we think the lines are, and the county would have it certified. We don't believe that is a proper solution to this matter. US Highway 2 is just to the north of us, and we have talked to Minnesota DOT people in the Bemidji office who have given us a map of the known markers along Highway 2. They should be able to be found. There's also a small lake that borders my property to the west along US Highway 2. Many years back, it was deemed as a US Fish and Wildlife waterfall protection area. I'm sure there are markers and monuments around it that could be found to reference these lines. On a side note, I'm also president of St. Paul's Lutheran Church in Lyngby, and after the new survey, it shows that one of our cemeteries, which was established in 1907 and has approximately 50 graves in it, should be another 500 feet further west. The family that owns the property next to the cemetery has had that property for many years and knows that this is not accurate either, and they are disputing the county's description. That pretty much concludes my testimony. If you have any questions, I will answer as best I can.
Thank you, Mr. Olson. Senator Kroon.
Thank you, Mr. Chair, and thank you, Mr. Olson. Question I have for you is you mentioned the new survey a couple of different times, and I'm just wondering who ordered that new survey and what were the circumstances on why that new survey was ordered that caused the problems in your view?
Mr. Olson.
I'm not 100% sure, other than I know some property was sold around here, and so there were different surveyors that were hired to survey this. And also, I know Polk County went through a process where they initiated the GIS system to just reestablish some lines. And that's when somewhere between 2010 and 2020, things changed. And that's when Daryl tried to apply for this new permit. So somewhere it was a combination, I think, of property being sold. I know of another individual that's a member of our church. It was to sell his property. It had it surveyed. It showed a building that he had built in 2009 or 10 was now on somebody else's property. They resurveyed it again, or did actually find the old markers, and then certified that that shed or shop that he had, garage, was on his property so he could sell it. But again, it cost him some attorney fees to get that rectified. And that was one of the issues in this township, Columbia Township, that's been going on, along with, there was another gal that lives right on the far south boundary of Columbia Township, that her and her husband had built a house and bought some property from a lady, had it surveyed, built the house and garage, lived in it for 30 plus years. all of a sudden, when she was getting ready to sell to her grandson who wanted to buy the property, it now showed that her property was on the son of the lady she had purchased it from originally. And so it went through a whole nother legal thing to try to get that back. I think it was, they did get that rectified, so she was able to sell it, but it was pretty much that landowner had to just say, no, this is where the line is and I accept it and you can sell the property. So there's been multiple things that have gone on in this township and also in the county.
All right, any other questions for Mr. Olson? Thank you, sir, for your testimony and for contacting Senator Green to bring this bill forward. We appreciate it.
Thank you for your time.
Do we have any other?
If I could, Mr. Chair, I don't,
Yeah, Senator Green.
I don't know if you did receive any other papers, but I do have a testimony from another gentleman who didn't wish to be online. He's an elderly gentleman, and his problem came about, he lives south of me in Monoman County, and because, if my understanding is correct, the DNR was looking at the plat books that they put out, which are not anywhere near legal, and it showed that they had moved the line from what the original boundary that he was established since he was a young boy, and his father owned the property, and they moved it into his field. And even our county roads are generally set on boundary lines. In this case, they moved the boundaries on the other side of the county road and into his field. And he didn't ask for a survey, he didn't ask for anything, as the state came out and said, looks like we own part of your property. And now, because he had an adjoining property, he had to buy a lease from them to cross the property that he had owned for years to get to his other section of property. And it's things like these that I just think that has gone far enough. And the GIS, I think, is no more accurate, because my neighbor had a survey done, and it moved my property line up to where it went right through the middle of my existing house, and which would have in turn, the house I grew up in would have not even been on our property. I had a survey done, and it still moved the line, but only by a few feet. And so whoever did the survey, and I think it was the same company, went off different pins, and so there's markers out there that I think we need to just to reestablish, and that's the point of this bill.
So thank you, Senator Green. For what it's worth, the book is Giants in the Earth. It was by Minnesota author Rolvog, and it was about a property dispute from settlers in the late 1800s. So I just looked it up, so no one need contact my office to correct me or anything like that. But if you want to see how far some of these property disputes could go, one person who thought they were selling the land came across the stakes and burned them. And the settlers who had placed the stakes and returned later couldn't find them. And there ended up being quite a conflict as a result. But here we're today focused on remedies, and that's what brings us to the Judiciary Committee. And the proposed remedy involves some court action. So we're going to ask counsel to please tell us what specifically we are asked to decide here today.
Mr. Chair and members, the specific language at issue is all on page 2 for purposes of this committee's discussion. And the issues for the committee are to determine whether the proposed language adequately provides a remedy for the situation that's been described before the committee, or situations. And if not, whether there are any other modifications that could be made or any other potential amendments to either of these sections.
So Senator Green, have you received any input from any lawyers that practice in this field as to whether the proposed language would be the best way to approach this? Has the Bar Association taken a look at this, for example? Do you know?
Mr. Chair, yes, they have approached me. I still haven't gotten the exact language that we should probably have, but it seems to me that it would just be changing of the statute sections that we're looking at. And I don't know if they're willing to testify, but there is someone from the Bar Association here now that might at least have something to say about that. And if that would be a fix, it would seem would be a simple fix. It's just where it fits in statute to change it over to abstracts.
Is there anyone here from the Bar Association that wishes to weigh in on the proposal before us? We have Kevin Dunleavy approaching, not a stranger to the Judiciary Committee. Mr. Dunleavy.
Mr. Chair. I think the question, what was the question?
Well, we've got this proposed remedy before us. Have you or someone from the Bar Association taken a look at it? Do you have any suggestions as to whether or not the language that's before us today needs to be changed or whether it's satisfactory?
We have looked at it. We haven't had time to come up with a suggestion for something else, but we recognize a lot of problems with it. And we're certainly happy to help, but timing-wise, we haven't been able to get the Bar Association gears turning yet. From a top-level perspective, one of the problems is taking one of the Torrens statutes and plugging it into abstract property. There's two different types of property systems in Minnesota, Torrens and abstract. The Torrens property tends to be concentrated in the Twin Cities. About half of Hennepin and Ramsey is Torrens. And then some of the outer ring metro suburb counties, maybe between 50 and 20% Torrens. St. Louis has a lot, but other than that, there's not. The rest of the counties have very small percentages of Torrens property. There is already a statute in the abstract law that provides for a survey. That's 559.16. And this looks at 559.23, which is exactly the right place for an amendment of the abstract property. But plugging it into Chapter 508 is not a good idea, because they're two different types of property. You know, and we don't want them blended because they have very different concepts. Another comment that I want to make is the GIS concept and the GPS concept. So surveys, the location of boundaries all relates back to the U.S. government survey system that was placed in Minnesota from about 1850 to about 1905. So about 55 years. They set the corners of each square mile, and then they set the halfway, they're called quarter section corners. They set those as well. That worked pretty well out in the prairie using wagon wheels to measure distances and rods and chains to measure distances and magnetic compasses. But when you get into northern Minnesota, into woods and in lake country, it doesn't work so well. Lake boundaries and water boundaries always have title problems. There's always survey issues. Northern Minnesota, because of the iron ore and the Iron Range, has, instead of mile square sections, it has triangular sections. And it has rhombuses, and it has trapezoids, or quadrilaterals. They're all different kinds of shapes. So unfortunately, we have to try to reestablish those locations when we're doing survey work in the U.S. That's the objective of all county surveyors and private surveyors, is to try to figure out where were those section corners and where are those quarter quarters. The technology is better, but it still relates back. We still have to go back to where it was in 1850. And GPS, for example, I'm a pilot, and with airplanes, the best location you can get with the GPS is about a cubic yard. And that requires a ground-based station, WAAS, a WAAS station, and the satellites. So a surveyor out in the field with a portable GPS or a GPS in your car is probably 40 feet off at least. they're not that accurate compared to what a surveyor can do. GIS also, the aerial photographs, if the camera is directly straight up perpendicular from the target, I do aerial photography too. So to take the picture from the top, straight down, 90-degree angle from the surface of the earth, that's not too bad. But the farther up it gets, the higher it gets, the location of the camera, the less accurate it is. If, on the other hand, the camera is off to the side, then the depiction of the ground is very distorted. So unfortunately, a lot of people, they're looking at their GIS and thinking it's accurate like a survey, and it's not. The only way you can tell where something really is with a survey, and it costs money, and nobody likes to do that. And I also heard a little bit of slander about real estate attorneys, and being one.
Oh, we don't want to go down that road.
In the one testimony, there were neighbors that were getting along. And when you have, that's not a bad situation. If you have neighbors getting along, you can make a deal. You can grant an easement, you can exchange deeds. You don't have to go to court. Yeah, you probably still need to get a survey, but that's the first thing you do when you have a boundary dispute, is try to get along. And unfortunately, a lot of times the people don't like each other, and the boundary dispute is just a symptom of an unfortunate relationship. But so anyway, I'll be quiet.
No, that's fine.
So, thank you, Mr. Dunleavy.
Oh.
Any questions?
Excuse me, sir.
Yes.
Mr. Chair, we are very happy and willing to help Senator Green with this bill. I just don't have it. I don't have something in hand yet.
Understood. Thank you very much. Appreciate that. Senator Kroon.
Thank you, Mr. Chair. I've looked at the bill and tried to think through all of the, how it would work in real life and some of the practical considerations, and some attorney comments have been forwarded to me. And I think the issue is real. It's a real issue that Senator Green's brought forward, and there probably is a workable solution to it. I'm not sure that this exact language gets at that, because what I'm being told and kind of how I'm looking at it is that there could be more litigation than is intended, and then having property owners and neighbors being thrust into litigation that maybe don't even know that they have a problem. And I know that that's not Senator Green's intent with his remedy. So I think, from my perspective, the best course of action would be to maybe to keep this in Judiciary, because I think this is the committee that needs to do this work, but lay it on the table to give Senator Green some time to work with the Bar Association. And then if we can get a workable product that gets squarely at the intent of Senator Green, then maybe we bring it back here before we send it back to state and local. That's just my suggestion.
Senator Green, what do you think about that?
I think that would be fine. The sooner the better, because it's affecting people today. And so I expect this is going to get much worse going into the future, because we're requiring surveys now if someone wants to upgrade their sewer. And so if we don't get this thing straightened out and find these original monuments, and I understand what the attorneys are saying, but the intent of the bill is actually to avoid that. If we knew where the markers were, the original monuments, then we could do the surveys when we have to, and the lines would be reestablished. But to come in and move lines that we know have been in place for as many years as they have is going to cause exactly what you were talking about with the disputes. And so we can argue over language, I guess, but if we can get it into the right statute in the abstract, and I understand the abstract part of it, because even my own abstract, I read it many times. When I've gone to do stuff with my property, it says that I own 40 acres more or less. And so, you have to have that boundary. You can't take out a tape and say, here's my 40 acres. And it's very important. So if you're willing to lay on the table, and I will certainly work with the Bar Association, and hopefully you'll be willing to take it off the table when we get stuff straightened out.
Senator Green, that's what we're going to do. I thought you were going to say you own 40 acres and a mule, but that's a whole nother historical story.
I'm stubborn. Does that count?
I can assure you, with everything within my power, we'll try to get this bill passed by May 19th.
Thank you.
But for now, anyway, Senate File 59 is laid on the table.
Thank you.
Thanks.
All right, members, next we're going to take up a suite of bills that address the issues that probably the sheriffs are in the room really to hear about, not the real property line disputes, which has to do with fleeing in a motor vehicle modifications. So we have, do we have Senator Gustafson or Coleman here yet? I know they've had other committee obligations as well. Okay, well, I guess I'm first up. I've got one of the three bills that we're going to take testimony on for informational purposes only today. The bills all have a somewhat different approach to solving this problem, and so we're going to get information. Senator Gustafson is finishing up a bill in one committee. Senator Coleman's on her way, I understand. So we will, for now, I'm going to hand the gavel over to the vice chair, and we'll go from there.
Senator Latz, whenever you're ready.
Thank you, Madam Chair and members. First, I want to point out that in your packets, Council has prepared a comparison of the three bills that are before us here today for the informational hearing. As I stated, I am chief author of one of the bills, and that is Senate File 1224. Let me lay a little bit of a foundation here. A number of years ago, Senator Coleman approached, I believe it was then Chairman Limmer, with a proposal identifying a gap in the felony fleeing in a motor vehicle statute between sort of less defined baseline fleeing in a motor vehicle on the one end, and then fleeing in a motor vehicle that resulted in very serious consequences, injuries, and so on. The gap was the kind of behavior that is particularly egregious, but may not necessarily result in a crash, injuries, or death. And the solution that she proposed at the time was creating an interim category where the behavior, the conduct in fleeing is culpably negligent. And that's been defined in other areas of the statute. One of the proposals before us has some specific statutes that would be violated that would also result in an elevated felony fleeing. So I agreed that that is a gap that ought to be filled in the statute. Senator Gustafson also picked up the ball on that issue, and also has a proposal before us today with some details that she can present when she's here as well. The reason I introduced a separate bill is not only because I agree with the culpably negligent interim or middle standard there, but also because in my experience and observation and the input that I have received, the lowest level fleeing in a motor vehicle, in my own personal judgment anyway, should not be a felony level offense. So fleeing is defined basically in the law as any kind of evasive behavior or conduct. So once the emergency lights come on with an attempt to stop a vehicle, a person who accelerates even 5 or 10 miles an hour, a person who makes a right-hand turn rather than pulling over right away, technically, under the law, that's fleeing. That contrasts, of course, with what we see in the news where people, jump on the accelerator, take off at 90 miles an hour, run through intersections and stoplights, and so on, which is obviously much more egregious and what I would say is culpably negligent. But for the lower level, especially for the ones who, may have a reaction which is poor and leave, but within a half a block or whatever the distance is, say, well, this is pretty stupid, and they back off and they pull over and haven't really put anyone else at risk in that short period of space, or haven't in fact risked anyone. Obviously, anyone who jumps out could be at risk. It didn't seem to me that was appropriate as a felony, which could put them in jail for over a year, and as our current forfeiture statutes are written, could result in the forfeiture of a motor vehicle, which is automatic upon conviction. So it was my endeavor to take that lowest level fleeing offense in a motor vehicle and make a gross misdemeanor out of it. That would take it out of the forfeiture statute. It would also change the license revocation provisions, and a portion of my bill, 1224, does that as well. Currently, on a fleeing in a motor vehicle offense, if you're convicted, it's an automatic one-year driver's license revocation. You're not even eligible for a work permit for the first 6 months, and after that, for the second 6 months, you are, only if a judge specifically authorizes it. So potentially a person would not have the ability, especially in greater Minnesota where transportation options are much more limited, to be able to get to and from work without relying on someone else to drive them. If there's no bus or other transportation available, if they work more than 5 or 10 minutes from their home, it means they end up having to quit their job. Which is also counterproductive, I think, in many ways, particularly if it's not egregious driving conduct that led to that conviction. So that's the genesis of my provision. I would like to see a bill that blends both approaches, which is why I had 1224 drafted. It changes the lower level to a gross misdemeanor, and it adds a culpably negligent feature in there, and it changes the license revocation, only applying to a second or subsequent violation. So I have received some suggestions that this should be left within the hands of the discretion of the prosecutors. And while I have a great deal of respect for prosecutors and for their exercise of discretion, I sometimes disagree with the manner in which they exercise their discretion, and there are some prosecutors who absolutely will not exercise any discretion. As a matter of course, if it's charged as a felony fleeing, they will insist on a conviction for felony fleeing. And sometimes they can get that conviction easily under the facts that are alleged, even if in the end I don't think justice ends up being served by such a conviction. So that's why if we go to a gross misdemeanor option there, it's available. And hopefully it would result in more justice being served depending on the facts of any particular case. Well, that's our proposal. That's my proposal anyway, which I would put in front of the committee for consideration. What I'd ask the committee to do is take a look at my bill, take a look at the bills from Senator Coleman and from Senator Gustafson, and ask questions, think about it, and then it's my hope that after today's hearing and after we get input from other public testifiers who are interested in this, maybe we can sit down among the stakeholders and the authors and come up with a proposal for the committee to consider that would blend the best or all of the proposals together for us to consider in a future hearing. And I think at least one of the other authors of the bill has arrived, so I've perfectly filled my time.
Thank you, Senator Latz. Senator Gustafson, we'll invite you up to the table. We've got 3 bills that we're going through today. So if you're ready to present, we'll hear from you and hear from our last author. And then I know we have a number of folks who want to testify. We'll take that, and then we'll move to questions. So you can go ahead whenever you're ready.
Everybody can hear how out of breath I am.
Were you fleeing someone to get over here quickly? Is that only a misdemeanor, wasn't in a motor vehicle.
Thank you, Madam Chair. Thank you, committee members. If you could just give me 1 second to switch from my jobs bills to my judiciary bills, that would be great. Okay, I think I'm set. Thank you, committee. Over the last several years, the number of instances for fleeing a peace officer in a motor vehicle has dramatically increased. In 2023, there were 2,262 agency-initiated pursuits in 2023. Law enforcement officers have experienced a correlation between the rise in fleeing and an increase in auto thefts. According to the BCA crime report that was released in August 2024, there were 15,612 vehicles stolen in 2023. That is nearly a 30% increase from 2019, when there were 11,410 vehicles stolen. This bill aims to address these concerns and works towards minimizing the amount of fleeing instances. Fleeing a peace officer in a motor vehicle is already illegal. The first 4 sections of this bill would amend the existing statute for fleeing a peace officer while in a motor vehicle by adding 2 offenses and raising the penalty by an additional year for each. So number 1 would be fleeing while exercising culpable negligence, would be guilty of a felony and may be sentenced to imprisonment for not more than 4 years. Current fleeing violation is 3. And then fleeing while failing to obey signs, signals, or markings, and or failing to keep on the proper side of the road, guilty of a felony and may be sentenced to imprisonment for not more than 5 years. The final section, Section 5 of the bill, would allow officers to utilize mobile tracking devices for fleeing vehicles by adding an exemption to the current tracking device law, which allows peace officers to use mobile tracking devices to recover stolen motor vehicles. That concludes my opening statement. Thank you. Sorry, Madam Chair, we do have a testifier. Sorry, I'm late to all of this. I don't know what the momentum is here for the bills, but we do have a testifier that is ready.
Thank you, Senator Gustafson. Yep, your testifier can come forward. We'll take that in the meantime. And if you can just begin by introducing yourself for the record.
Jay Henthorn.
And please proceed.
Thank you, Madam Chair, members of the committee. My name is Chief Jay Henthorn from the city of Richfield. I'm here today representing the Minnesota Chiefs of Police Association. We represent over 300 police chiefs across the state of Minnesota and over 150 command staff members. We want to thank Senator Gustafson for authoring this bill. We believe that in light of the frequency of pursuits and the varying levels of danger associated with the high-speed pursuits, the proposed modifications to the fleeing statute better align with the severity of the crime. Additionally, the existing exemptions for the use of mobile tracking devices by peace officers require the consent of the owner of the vehicle has been obtained, or the owner of the motor vehicle has reported to the law enforcement that the vehicle has been stolen. Both of these exceptions serve an important role and require the device to be removed within 24 hours of its deployment. Officers have found that in order to receive consent from the owner or to receive confirmation that a vehicle has been reported stolen are not practical when a vehicle is fleeing. When an officer runs a plate in the system, they are able to see if the vehicle has been reported stolen. But county attorneys require that the officer receive confirmation that the vehicles are reported stolen. That process takes several minutes. By this time, the vehicle is long gone and the ability to use a tracker is lost. In cases where a device is deployed, the officer is able to back off from the fleeing vehicle and avoid a high-speed chase that would cause a threat to the community's public safety. Following high-profile incidents, during or resulting from high-speed chases, Many agencies have revised their policies to simply not pursue. As a result, it becomes harder to catch the individuals responsible for either stealing cars or endangering the public due to high-speed fleeing. By deploying a device onto the fleeing vehicle under the reasonable and practical exception described in this bill, the officer can back off from the pursuit or keep the motoring public safe while also maintaining the ability to find the individual or vehicle. Lastly, we believe the original intent of the mobile tracking bill allowed for it to be used in the manner that I've just described. However, some county attorneys have opined that the law would need to be changed to allow for it. That is why we are here today. Thank you for the opportunity to be here today to discuss this important issue.
Thank you, Chief Henthorn. I'll actually ask if you can hang tight, but I see that Senator Coleman is here with us, so I'd like to invite you to come forward. We're hearing all three bills, so it would be great if we could have you present your bill. We'll go back to testimony, and then we'll move into questions from the committee. So whenever you're ready, Senator Coleman.
Thank you. Just one moment to get together. I didn't know I'd be up next, so I appreciate it. Thank you, members, for the time. This is an issue that I've been working on for several years after, and I'm sure many of you have heard the story. I just brought my twins home from the hospital, and we were driving down 212, actually on our way to the Capitol, all three of my kids in the minivan, and I look to my right, and I see this device being pulled across the highway. I look to my left, and I see the officer pulling that device and watch it go under my car tires, and it all happened so fast. I hear screeching tires, screaming kids, and my husband, who is a first responder, was alert, knew exactly what was happening, and quick swerved out of the way of a vehicle that had been stolen in Medina from crashing into the back of my van where my kids were sitting. And I, kind of going into mama bear mode, call up my local sheriff and go, what are they getting charged with? Like, what are their punishments for endangering my family? And he said, well, unfortunately, they're only being charged for fleeing the police. There's actually no crime for them endangering your life in the process in the state of Minnesota. And that's when we started working with our team a couple years back to identify this gap in statute so that if you are endangering the public while you are fleeing the police, that is an added crime. Because I feel what happened to me and my children that day was unacceptable and absolutely should be a crime in the state of Minnesota. I believe you've heard all of the statistics, and so I'm so excited that we have law enforcement on board, Democrats and Republicans on board with this, because it's just something that is near and dear to my family's heart, and I'm sure everyone else who's been on the road experiencing that. Madam Chair, I don't know if you want to save individual testifiers till the end, but I do have one testifier with me, if that's all right.
Yes, thank you, Senator Coleman. You can bring your testifier forward. And thank you. You may begin your testimony. Just begin by introducing yourself for the record.
Yes, hi. Thank you, Madam Chair. Kevin Torgerson. Madam Chair, Committee, I'm Kevin Torgerson with the Olmsted County Sheriff's Office. I'm here speaking today on behalf of the Minnesota Sheriff's Association. We strongly support legislative efforts to strengthen accountability and ensure that individuals who flee from law enforcement face meaningful consequences. Strengthening laws related to fleeing a police officer is critical in addressing the increasing dangers associated with people who refuse to stop for peace officers. Fleeing a police officer in a motor vehicle has become a disturbingly frequent and hazardous crime. More suspects, often repeat offenders, and sometimes as young as, imagine, your 12-year-old grandson or child being the driver in that vehicle, engaging in these high-speed pursuits. These dangerous incidents put law enforcement officers, innocent motorists, and pedestrians at severe risk. Pursuits frequently result in serious crashes, injuries, and fatalities. The use of stolen vehicles in these crimes has also increased, making it even more difficult for law enforcement to safely apprehend offenders. Current penalties do not provide sufficient deterrence to discourage the reckless behavior. Offenders, particularly repeat offenders, view fleeing as a viable option with minimal consequences. They know that we weigh the risks at every second during this pursuit and know that we will stop and they will continue. By strengthening penalties, we are reinforcing the seriousness of these offenses and making it clear that such reckless disregard for public safety will not be tolerated. Holding individuals accountable for fleeing law enforcement is not just about punishment, it's about protecting lives. Every high-speed pursuit poses a threat to everyone on the road, and those who choose to flee understand that their actions carry real consequences. The prevalence of young offenders engaging in this crime further emphasizes the need for stronger legal deterrence because there seems generally, in many cases, not to be consequences at home. Without significant repercussions, these individuals will continue to put the public at risk, often escalating their criminal behavior. From a law enforcement's perspective, fleeing crimes create highly volatile and unpredictable situations. Deputies and officers make split-second decisions to balance public safety with the need to apprehend dangerous individuals. Stronger penalties will act as a deterrent to those who might otherwise choose to flee. These legislative changes also provide the opportunity to educate the public, especially young drivers, on the grave consequences of fleeing the police. By strengthening these laws, we make it clear that fleeing law enforcement will result in severe consequences, discouraging dangerous behaviors before it starts. There we go. The law must reflect the severity of the offenses. However, accountability must be paired with the intervention programs, particularly for juvenile offenders. Most young individuals engaging in this behavior are not only repeat offenders, but are also at risk of escalating into more serious criminal activity. Early intervention through structured programs can break this cycle. These programs must work alongside law enforcement efforts to ensure a holistic approach to public safety. The Minnesota Sheriff's Association urges the committee to move forward with these important measures. We appreciate your work of this committee and the efforts to strengthen accountability in our justice system. Public safety is a shared responsibility. We thank you for supporting this effort.
Thank you for your testimony. And I want to thank all of our authors for bringing forward the bills. I just want to ask if there's anyone else who wants to testify towards any of the bills today. Rich Neumeister, if you like to come forward, and I think we have one other testifier. Could make space for our testifiers, and then we'll go back to the bill discussion. And Rich Neumeister, feel free to come forward as well.
Grab a spot, Rich. Madam Chair and members, my name is Shane Myrie. I'm the president of the Minnesota Police and Peace Officers Association, or MPPA. Thank you for the opportunity to testify here today on the topic of fleeing police in a motor vehicle as it relates to Senate File 191, 323, and 1224. Fleeing suspects have created a public safety crisis on our roadways. They create dangerous and sometimes deadly consequences for themselves, innocent civilians, and law enforcement. When we talk about fleeing police in a motor vehicle, here are our example of 5 different scenarios, not all encompassing, but just different scenarios our rank and file peace officers will face on the streets of Minnesota. First, a traffic stop where a vehicle occupant originally stops and then decides to flee from a stopped position with the officer outside the car door. That decision to flee could be based on the warrant status of the driver or an occupant of the car, or it could be based on vehicle contents, if there's something in the car that the occupants didn't want the police officer to potentially uncover. Second is going to be an attempted traffic stop where the vehicle occupant decides not to stop at all on the roadway. Again, the same reasons may be there for that warrant status of a vehicle driver or occupant or contents of the vehicle. Third is going to be just a suspect actively fleeing a crime that they had just committed. Now, the next 2 examples are going to be dangerous trends that we're starting to see here in Minnesota. A suspect or a group of suspects are going to steal a vehicle. They're going to engage in multiple violent crimes throughout a geographical area using that stolen vehicle. And then they're going to repeatedly flee from law enforcement as we attempt to stop them, eventually getting to a point where they'll dump the vehicle and either flee on foot or dump the vehicle at a location where there's another vehicle already staged. And lastly, at a predetermined meeting location distributed on social media, groups of individuals get together with vehicles with the intention of causing problems on the streets. Essentially, they're baiting law enforcement into pursuing him, and then they flee. I won't get into the details of it because I don't want to promote it, but we have some recent postings on social media where it's a group of individuals, time and location, and the language that they use in their posting is stay together until chased. So they get together, stay together until they're chased, and then you've got cars fleeing multiple different directions. In light of just those 5 different examples, our members with MPPOA are looking for a comprehensive approach involving modifications to the Minnesota Criminal Code and then some modifications around 626A as it relates to an exception for an actively fleeing motor vehicle. With regard to the criminal code piece, we've heard that talked about with previous testifiers. There's a gap right now between the simple flee and then the tiered approach for death, great bodily harm, or substantial bodily harm. So if you find a middle ground in there addressing that culpable negligent driving behavior, which is going to address driving behavior like driving on the sidewalk or driving through a city park, or in some situations, it's driving the wrong way into oncoming traffic. Next, with regard to the proposed language in Senate File 191, creating that exception under 626A for actively fleeing motor vehicles, our members support this change for 3 simple reasons: safety, safety, and safety. If law enforcement is able to apply a mobile tracking device on an actively fleeing vehicle, as was mentioned earlier, it creates space between the stolen and fleeing motor vehicle and law enforcement. So an arrest operation plan can be developed and implemented at a time, place, and manner that's dictated by law enforcement personnel. Madam Chair and members, thank you for your time, and thank you for bringing up this important issue in committee today.
Thank you for your testimony. Rich Neumeister, if you would like to testify, just begin by introducing yourself for the record.
Madam Chair, members of the committee, thank you for the opportunity. And it's also great to have a lot of my adversarial friends historically in sheriffs and law enforcement, because policy-wise, I've been on the opposite side of many of the things that they've done over the decades. The issue here is from Senator Gustafson's bill, and it's the tracking device. Tracking device has been a big issue here in this committee for the last 3 years. And part of it is not being addressed here, but might be eventually, but it's the fleeing one, and it's an issue for me. Technology has changed the dynamics of law enforcement, and public policy does not keep up with that technology. And one of the things that I have a concern about is that this is a slippery slope. It's very clear under law that a tracking device can be placed on a vehicle in exigent circumstances. That is very clear. We also are clear that placing a tracking device, according to the Jones case of a few years ago, that it is a search. So there are some Fourth Amendment issues that come into play in putting a tracking device on. So the issue is, how do we want to do that legislatively, in case law, or whatever? My suggestion is not let the bill pass. Case law is very clear in exigent circumstances. Even if you're going to add flee, does that meet an exigent circumstance in terms of the statutory definition? Now, Madam Chair and members of the committee, if you want to go forward, because I know this will be more discussion probably when it comes up for votes, as to what options you can have, what I can suggest is you put language like this. You place in law to specify tracking devices can be placed without a warrant under exigent circumstances when there's a threat to public safety. And then you have a post-event judicial
kind of documentation in the record or of the case or whatever, so people can always go back and look. Number two, you can adopt this language, which is being proposed, which I, again, have concerns about, but then also authorize some kind of documentation. Now, when you look at the amended part of the law, you'll see where there have been some of these exceptions. And you will also notice, because as Senator Latz and Senator Limmer know, this has been a more than 2-hour issue over a period of several meetings back in the past, that there was a reporting mechanism in there in another part of law that when a tracking device can be on for 24 hours without a search warrant. So maybe something could be finessed when this comes back up for more accountability. The bottom line is people are concerned about use of technology by law enforcement. And every more, it's important for those kinds of things to be documented. So Madam Chair, members of the committee, that's my 2 cents. And it's always a pleasure to make my comments sharing with you.
Yes, thank you for your testimony. And I'll ask all the authors to come back to the table. I think we'll have some committee discussion now. So I did just want to start with one question that I have, and I understand we have a number of people here to testify as well. I just wanted to make sure I had you all back at the table. So one thing that all the bills have in common is adding the felony for felony fleeing culpable negligence. Sort of the scenario you were talking about, Senator Coleman, something that's really putting others' lives at stake. There's a slight difference in terms of the years and the fee between the bills, but I think the intent there is to fill the gap, which I totally agree with. On the existing felony fleeing, Senator Latz's bill does change that to a gross misdemeanor. One of the reasons I believe for that, but you can correct me if you're wrong, Senator Latz, and this gets to one of my concerns, is just fleeing could this situation could be considered fleeing where someone would take like a right turn to get off of a less busy roadway, which also feels like a safety concern to get into a situation where they could pull over. So I would just love to hear from Senator Coleman, Senator Gustafson about that sort of scenario, if it's your intent for that person to actually be charged with a felony, or if you think there's a way to address that beyond what Senator Latz has proposed.
Thank you, Madam Chair. My experience in driver's training and I suppose having a dad on patrol for most of my life and him repeating to me again and again is, if you're going to go to a safer location, if you're going to exit the highway, if you're going to take a right turn, what have you, you should indicate to the officer that you know they are there and turn on your hazard lights, slow down, and that way they know that your intent is to not flee and to get to a safer location. I'd be more than happy to hear from law enforcement if they would think somebody going the speed limit and pulling over at a different location would indicate to them that that's fleeing, but I can't imagine that it would.
Thank you, Senator Coleman. Senator Gustafson?
Thank you, Madam Chair. I concur. I just want to make sure I understand the question. You're talking about if there's a high-speed chase, such in Senator Coleman's, does that, maybe I
No.
misunderstood?
So again, I understand that all of the bills are trying to address the gap where there is culpable negligence, which you're adding that in and adding a felony. I'm talking about existing felony fleeing, where this is a change that Senator Latz has in his bill, where it actually brings it down to a gross misdemeanor. And thinking about a situation where, because of kind of the current definition of fleeing, if someone were to take a turn in order to get off of a less busy roadway, that could technically be considered fleeing. And is it your intention for that person to actually be charged with a felony, or do you think there is a different way to sort of handle that situation where someone is trying to ensure safety, right, for themselves and the officer.
Thank you, Madam Chair. As I read the bill, it does not include that. It is specifically for the person fleeing, and I would just concur with what Senator Coleman said. There are usually indicators, and I'm sure law enforcement can, back this up, that there are indicators if somebody is making an attempt to pull over versus if they are also engaged in fleeing as well. So maybe our testifiers could speak more to real-life circumstances that would define the two a little bit better in those situations, but it is not what our bill is trying to do.
Thank you. Senator Latz, did you want to comment on this at all?
Sure. Thank you, Madam Chair and members. I'll just refer you to Chapter 609.487, which is the crime for fleeing a peace officer in a motor vehicle. Subdivision 1 defines fleeing. And the language in the statute, flee means to increase speed, extinguish motor vehicle headlights or taillights, refuse to stop the vehicle, or use other means with intent to attempt to elude a peace officer following a signal given by any peace officer to the driver of a motor vehicle. So we could break that down. Increased speed could mean accelerating 1 mile per hour. I'm not saying this happens all the time, but I'm saying this technically would be a felony offense under existing statute. Increasing speed by 1 mile per hour. Turning off your headlights or taillights, which I understand. I mean, I've seen case law if it's at night and you're in a rural area and you think that maybe if you turn off your lights, the officer's not going to be able to see you. That might be an attempt to elude the peace officer. But there might be other circumstances where that would not be. Refuse to stop the vehicle. So just failing to stop the vehicle would be a felony offense under those circumstances. Or use other means with intent to attempt to elude. So a right turn, they'd have to prove intent of the attempt to elude. So they're making a right turn to get off of a busy highway to find a safer spot to pull over, presumably would not be, but that would be in the eye of the beholder. An officer could conclude that that was an attempt to elude the officer and bring it to the city attorney or the county attorney's office to charge it out as a felony. And then you've got the defendant trying to hold a prosecutor to not be able to meet their burden of proof beyond a reasonable doubt in a jury trial over that issue. Those would be felony level offenses. Now, to me, that's sort of bare minimum inappropriate conduct, if you will, that wouldn't justify a felony offense, which the minimum felony under this statute is a 3-year, $5,000 felony. So it's not even a 1-year felony. It's a 3-year felony maximum, 3-year and 1 day maximum penalty for that level of a felony. And that affects where it falls in the guidelines, sentencing guidelines grids for presumptive sentencing and so on as well. So that's the justification for my suggestion that the lowest level be a gross misdemeanor. And then when you get into culpably negligent conduct, you get into conduct that violates certain statutes. To me, that's more appropriate for the felony level offenses, which are, of course, very serious and appropriately so.
Thank you. I just want to see if there are any other testifiers who wanted to speak to that question before I go to other members of the committee. Okay. Senator Kroon.
Thank you, Madam Chair. Thanks to all three of you for bringing these bills forward. Important bills, an important topic. And I just had a few questions. We'll start with the one we were just talking about, which is how Senator Latz's bill differs from the other two bills. And obviously it's probably not a surprise that I have concerns about making any fleeing go from a felony to a gross misdemeanor. I understand what you're saying, but and I'm reading the definition now, and I think it's pretty clear, and I think if a person is fleeing a police officer, it should be a felony, even if it's their first time, and even if, what exactly that means. But I do think it should be a felony, and you said something about, well, their reaction could be poor, or they might make a right-hand turn, and technically speaking, that could fall under fleeing, but, you know, I can't imagine that those scenarios would ever be charged, certainly not convicted, because they're not fleeing, in my view. But I will just maybe ask Sheriff Torgerson or the police chiefs or MPPOA what they think about that provision, which lowers the fleeing from a felony to a gross misdemeanor.
Chief Potts, go ahead.
Madam Chair, and my name is Jeff Potts. I'm Executive Director for the Minnesota Chiefs of Police Association. To Senator Cruin's question, you know, Senator Latz did read the definition, and perhaps I think the scenario that he described, you know, you might make an argument that that's the portion that says refuse to stop the vehicle. You know, perhaps they're not increasing the speed, they're not extinguishing their lights, or making, you know, other obvious attempts to elude the peace officer that's trying to stop them. I guess I think our association's position is that from a practical standpoint, Senator Cruin, I think you're correct that those are not cases that are being charged with fleeing. Perhaps they're being charged with fail to yield to an emergency vehicle, which is, I believe, a misdemeanor. I'm not aware of any scenario. My experience as a police chief is in the Hennepin County, but I now represent 300 police chiefs across the state from all cities, all sizes, and I think our experience would say that those are not being charged with felony fleeing. And if you're asking that, what is our position on? In light of the number of pursuits, it was already testified over 2,600 last year that were reported. Perhaps there were some where that pursuit was immediately terminated that aren't even included in those numbers, that when someone makes the decision to flee from the police, our goal in this whole, in the bill Senator Gustafson brought forward, is to really kind of break that down into varying levels of severity, and essentially tied to danger. We appreciate the language on culpable negligence. It's a legal term that means to, without reasonable care, putting others at risk. We think there's even room for another tier before it results in great bodily harm or death, and that's that pursuit where they make the conscious decision to drive into oncoming traffic, really putting other people at risk, even higher than, I think, culpable negligence. And so it's our position that even the lowest level should not be reduced to a gross misdemeanor, that's a conscious decision to flee, putting everyone on the motoring road in danger, the occupants of the vehicle, even bystanders, that should remain at the same level. But there's tiers that make it, that go even higher than that we've brought forward in the bill authored by Senator Gustafson.
Senator Cruin.
Thank you, Madam Chair. Does the Sheriff's Association have a position on this?
I guess speaking on
Mr.
Kevin
Torgerson.
Torgerson again with the Sheriff's Office, I can't really add anything different than what Mr. Potts did. That's exactly where it's at. We're constantly evaluating. It's the training that the deputies, the officers go through to constantly evaluate the behavior of the vehicle in front of them, the occupants inside. And there is a difference between whether someone's looking for a place to stop and not stopping. And you're continually evaluating that, looking for what happens. Obviously, when some of these more egregious things start to happen, now we're looking at termination because of the other risks that start to involve. So I agree with what Jeff said. I couldn't add anything more than that, but thank you for the time.
Senator Cruin.
Thank you, Madam Chair, and thank you for those responses. I'm kind of in the same boat. I think this is a big enough problem where it would be a real mistake to reduce any fleeing down to a gross misdemeanor. But trying to get my head around like what kind of numbers are we talking about here? If we were to do that, Senator Latz, has there been like a fiscal note that talks about the implications from a prison bed standpoint, what it would mean if we did reduce it from a felony to a gross misdemeanor?
Senator Latz.
Madam Chair, Senator Cruin, I don't believe I haven't seen the fiscal note yet. I'm not sure where it is in the process. I'd be interested in the same information. Maybe Mr. Turner has something more to share on that.
Mr. Turner.
Yes, Madam Chairman, members. The fiscal notes for all three bills have been requested. They'll be complete next week. There was a fiscal note based on a floor amendment last year that did address this. And according to that fiscal note, there were an annual average of about 600 cases filed on the 3-year simple fleeing felony that we're talking about. And of those, an average of 78 resulted in prison sentences.
Senator Kroon.
Thank you, Madam Chair. I mean, I'm looking, is it the A69 fiscal note? My understanding, my interpretation of that is it would actually reduce the number of, fewer people would actually go to prison. That number would be 78 over a 10-year period, I believe, is what the implications would be. And so I'd be interested in seeing where that, and I think that comes from the Sentencing Commission guideline. I'm not sure exactly where that comes, I think that's where it comes from, but I'd be interested to see what they say this time. But either way, I think that's kind of the wrong direction from my perspective, in that we shouldn't be reducing any fleeing from a felony to a gross misdemeanor. When somebody makes that decision to flee a police officer, that's a very, very serious decision that they're making. And even if it doesn't result in anybody getting hurt, I think the serious of that should be dealt with at the felony level. And then the one other question I had, and I appreciate the intent and the goal of creating these different categories above that and this culpable negligence standard. And I know that comes from, I believe, manslaughter and the manslaughter statute. And I think it was Mr. Potts gave us a definition, acting without reasonable care and putting others at risk. I was just wondering if that is the actual definition, or do we have like a formal definition of that somewhere?
Mr. Backus.
Madam Chair, members, so the culpable negligence standard is, I believe, used 5 times in law, most notably in the second-degree manslaughter statute. I would say the actual standard appears in each of the bills in an identical fashion, because it talks about operating a vehicle in a culpably negligent manner whereby the perpetrator creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. So there's an objective kind of negligence standard that's also connected with a conscious, essentially a recklessness standard, a conscious standard of taking that risk. I have more information about it if you wanted me to read it from one of the treatises, but I don't have to do that if you don't want to.
Senator Kroon.
Thank you, Mr. Chair, and thank you, Mr. Backus. That's helpful. I guess maybe my hang up on all this is that I think all fleeing rises to that level myself. And I know we're trying to create different categories. That's just me. I just don't have any patience for anybody that would do this. But I appreciate the effort to try to have these different standards and to try to create this new one. And as to Mr. Potts' point, maybe another one about driving the wrong way down a freeway or something. Whatever's actually happening out in the real world that puts people's lives at risk, I think I'm certainly open to enhancing penalties for that. So I appreciate all the bills. I can't support Senator Latz's provision to have it go down to a gross misdemeanor, but I thank you all for your efforts and look forward to future discussions on this. Thanks.
I'm going to let Senator Latz respond before we go to further questions.
Well, thank you, and I appreciate Senator Cruin's position on that. I'm going to give you a quick example. I had a case probably 20, 25 years ago now where a young woman who'd been watching sort of social media, maybe it wasn't quite that long ago then, but where there was a thing out there where there was concern about people faking as if they were police officers. And it was at night, and she saw the red lights behind her, and she was scared that maybe it was one of those fakes, and she didn't stop right away. And she sped up a little bit, and she made a right turn. This was at night, and she got charged with felony fleeing. She didn't put anyone at danger. She didn't come close to hitting pedestrians. She didn't cut off any traffic or, run a red light or anything like that. But she got charged with a felony. And I have to tell you how hard I had to work to convince the prosecutor to drop that down to a lower level offense. It would have been a complete injustice. She had no prior offenses on her record. It would have been a complete injustice and would have dogged her for the rest of her life to have a felony conviction on her record. That would not have been right. And while, most officers may not charge it out that way, this one did. And most county attorneys may not pursue it that way. This one did right up until the bitter end. So there are cases out there where it would just be complete injustice for it to be a felony charge. Just the charge itself is going to show up on a background check. And you end up with a plea negotiation, even gets dropped to a gross misdemeanor. That person is still going to answer every job application where they get an interview, why they got charged with a felony. And to me, that's just not fair. So I'm trying to create space for those cases where that situation would not be a fair situation.
Senator Cruin.
Thank you, Madam Chair. I appreciate that response. And the problem here is, first of all, it sounds like it got appropriately charged at the end, thanks to your good lawyer work. But this would open up the door too wide, I think. Because yes, there could be a situation where somebody doesn't believe it's a police officer. I'm sure that that comes up from time to time. But to take it down automatically in this sense to a gross misdemeanor opens it up to far more people that should be being charged with a felony that wouldn't, than it would be people that are charged with a felony that maybe shouldn't be. And so you have to weigh the balances there, and each case is going to be a case-by-case basis and a fact issue on whether or not that person truly believed that the person that was attempting to pull them over was a police officer or not, and what their basis for that was. And we're always going to have those fact situations, but to take the whole thing and then make those first-level offenses to be gross misdemeanors, I think does far more damage than it does to protect somebody that might have been caught up in that situation that ultimately was resolved in the way that you think it should be resolved. So again, I just don't think that we should be reducing these fleeing situations, particularly with the problem it would send the entire wrong message out there that we're reducing the penalties for fleeing rather than increasing. And I think that is evidenced by the fact if that fiscal note does come back with 78, that would show a whole lot of people that would be going to prison, wouldn't be going to prison. And of those 78, virtually none of them are going to be that kind of story that you just articulated. They're going to be people that should have been charged with the felony that aren't.
Senator Limmer.
Thank you, Madam Chair. As I've been looking at these three bills, I'm trying to take more of a broader approach on it. My first question, whenever I consider consequences for a criminal action, I always try to consider what are we trying to accomplish first. Question of deterrence is always a question that I wrestle with. I'm beginning to realize that perhaps the written law has become less and less a deterrent because people that break the law in a case like this aren't necessarily reading the statute books and trying to determine what the consequences are. It's more of a, I don't know, whether it's a crime of a passionate response to lights behind your car. Certainly the public, I think, almost has a retribution mentality when they see someone breaking law in this manner, fleeing from a police officer and creating a very serious safety hazard on the streets in our communities. And as I've looked at it, I'm not going to speak exactly about every single bill, but I do agree that there should be a graduation of consequences based on the driver's behavior. You could bring in a number of factors. Is it a stolen car? Is it are they driving in a reckless manner? How serious is the reckless manner that they're driving in? Is the time factor of being on the road, being followed by, and fleeing a police officer, is that a factor? Does the person pull over after a few blocks, or is it miles and miles and an hour of driving in circles around a community? And we've seen that by hijacked cars in the last few years. I noticed the reference to statutory maximum sentence. It's not to be confused with mandatory, it's statutory. We're creating a larger range of consequence, and that triggers the factor of judicial discretion on how a judge would, after listening to the case, finding a conviction, and then allowing the judge a little wider range of consequence for the perpetrator. I've always believed in judicial discretion. It's very difficult for us to, from our vantage point here, to consider every single possible case that could come before the courts. And I think it's important, I believe in a wider range. I believe in a wider range that the judge could pick and choose the consequence for the perpetrator. And that would also apply to the suspension of the driver's license. So I'm just going to give some general ideas. I like a wider range, a larger possibility for a sentence to be a bit more severe. I believe in the suspension of a driver license as well as a fine to be a wide one, and leave it in the hands of a judge's discretion to pick that consequence that fits the crime. I don't think it's, in this case, I can't move in the direction of reducing the consequence, simply because we are dealing with a person that is refusing to recognize the safety of individuals around them. They're denying or diminishing the authority of a police officer's authority. That's another factor that I'm rolling around in my head. And there seems to be a lot of that happening more and more all the time, that the authority of a police officer's order is being ignored or being run away from. And I think that's an important factor to consider as we eventually arrive at some conclusion on this issue. And so I'm going to lean more in favor of judicial discretion with a wider range of sentencing, and that would fit toward suspension of a driver's license and/or a financial penalty. And keeping in mind that we're dealing with public safety, we're dealing with the authority of a police officer.
Madam Chair. And actually, I am going to, since we're a little over time, just move to you all having closing comments. So if you want to begin, Senator
Sure,
Coleman, to address
absolutely.
that and anything else you wanted to share about your bill.
Thank you, Madam Chair. Thank you, Senator Limmer, for the point you raised of what is the point? What are we trying to achieve here today? And I would certainly hope that deterrence is obviously one of those goals. But when you brought forth that question, my first response was, at a certain point, it's justice for everyone else that was on that road. When my family and I went through that, it was a long time before I could even put my kids in a car again. In fact, I had to because they had to go to a checkup. It was even longer before I could drive past that stretch of road without shaky hands and breath and heart palpitations. To this day, I am watching my rearview mirror like a hawk, making sure there's not a car coming up about to crash into me. It is justice for everyone whose lives were just thrown out the window when they decided to flee peace officers in a dangerous fashion. So I'm sincerely grateful to Senator Latz for allowing me to bring this issue forth that I've been bringing forth for 3 years now, and am willing to work with anyone at this table in this committee to get this across the finish line this year in a way that is realistic, knowing that we have such a closely divided legislature, that we can at least do something, even if not all of our goals are accomplished this year. So thank you for the time and consideration.
Anyone want to go next? Senator Gustafson?
Thank you, Madam Chair. I will yield my time of a closing statement and maybe just point out the one difference in my bill that stands out, and that neither of the other two bills have the exception to the use of a mobile tracking device. And I can yield my time to one of our testifiers who could just briefly explain that a little bit more, if that's helpful to anybody.
Sure, if you want to bring your testifier forward.
Yeah.
Good afternoon. Chief Melbourne with Edina. I've been there for about 3.5 years, excuse me. Battling the back end of a cold. And I was with Brooklyn Park for about 29 years before becoming the chief for Edina. So real briefly on mobile GPS tracking devices, what we're intending to do and what we're looking at is there are some narrow parameters around allowance of that device or those devices. We in Edina, we have that software on our squad cars, and we use that pretty effectively. But what we're asking for, what we're seeking through some of the issues are that current law does not allow us to deploy those all the time. And so there are circumstances, for example, when an officer might not get a report of a stolen car quickly and early, and there's a delay in that. And so a good example of that would be a car that's stolen from a garage. The homeowner might take some time to report that. There's a delay, a number of hours before that officer takes that report, and an officer behind a stolen car has no information that that car is actually stolen. In other words, it's not entered into the system. So that's one example of how those devices could be impacted by that, or the law set up in such a way that won't allow us to deploy those GPS devices. And what we're always after is safety. Pursuits are dangerous, inherently dangerous and risky. And so that software and GPS devices allow us to be more effective and more safe in the manner in terms of how we go about pursuing dangerous criminals out there.
Thank you. Senator Latz? Okay. Well, with that, our next hearing is Monday, February 17th at 12:30 p.m. following floor session if that goes over. And with that, committee is adjourned.
Yeah.